This account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many, I suspect, who are worried about their immigration situation, but they're not sure if they should speak to an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if you think that your situation is nearly identical to one of the ones that I go over here, you still need to speak to an immigration attorney personally. Even the smallest factual changes can make a big difference in the outcome. That said, this is not legal advice. I'm hoping this will merely help educate people as to how the immigration laws work, because I know there are a lot of anxiety exists in certain immigrant communities. Also, immigration laws and procedures will likely change quite a bit in the months to come. So what might be accurate and current at the time of this recording very well could change in the weeks to come, maybe even tomorrow. All right, so USCIS just announced a new policy regarding adjustment of status. And essentially what they are saying is that adjustment of status, which has always been discretionary in theory, they are now regarding it as only applicable in extraordinary circumstances. So what does that mean? Well, someone could be eligible for adjustment of status, meaning they entered the United States legally, and then they either have an employment-based case or a family petition that makes them eligible for adjustment of status. However, under this new policy, they're saying that no, you need to show that your situation involves extraordinary circumstances that warrant us allowing you to process your green card in the United States rather than having to go back to your home country and process there. This is a huge departure. For as long as I've been practicing immigration law, adjustment of status, yes, it's been discretionary, but that being said, generally adjustment of status cases were approvable and would get approved. So this is a big change, and it's going to, what I predict is that with this new policy, we will see a lot more requests for evidence or notices of intent to deny, where USCIS says, yes, we received your adjustment of status application. We need more information on why you think that you warrant this extraordinary form of relief. So that could be, I've lived here for 20 years. My children are here. They're young. They go to school. My spouse works, and I need to either stay home with the kids or I need to work as well. And it would cause a lot of hardship for me to go out of the country for potentially several months at a time to process my green card. So possibly that would be an extraordinary circumstance. There's a lot of questions that are unanswered around this new policy, and we don't really know yet. But I think that requests for evidence will tick up. I think reading the policy, it seems that it is not going to just affect prospective cases, but it will affect any pending cases as well. So if you have a case that you filed months ago and you're still waiting for a decision, I would imagine that this new policy will affect your case, even though it wasn't in effect when you filed. That's just the way I'm reading this. In terms of who this doesn't affect, it doesn't say exactly what types of cases it won't affect, but 245I cases I don't think will be affected by this. That's my reading. U visa cases, VAWA cases, okay, so victims of domestic violence. Military parole in place, I believe those also won't be affected, just from reading the rather vague language of the policy. I think those are all going to not be affected by this. The policy memorandum specifically states that dual intent non-immigrant status situations will not be affected. So if you have an H-1B and you are applying for adjustment of status to a green card, H-1B is dual intent. So that will not affect, that should not be affected by this memorandum, and you should still be able to adjust status. Now, how are they going to analyze extraordinary circumstances? So they're they are absolutely not specific on how they will analyze extraordinary circumstances and what constitutes an extraordinary circumstance. But I think that a strong argument can be made that if someone entered legally maybe 2 decades ago, they overstayed, and now they are eligible for adjustment of status, possibly through marriage to a US citizen. A strong argument can be made that if you force this person to process through the consulate, they are going to need a waiver around their unlawful presence. And a 601 waiver can take a year, 2 years, maybe even longer to adjudicate. So this person would need to return home, process a waiver, stay out of the country for a very long time while they're waiting for that waiver, and then come back into the United States. I think that we can make a very strong argument that that is an extraordinary circumstance. Now, compare that to a situation where someone enters on a tourist visa, maybe 3 months ago, and then applies for adjustment of status due to their marriage to a US citizen. I could see those cases getting denied and the people being forced to consular process because they don't have their roots as firmly established in the United States. And it would be harder to argue that it causes, extreme hardship to go back home and process your case through the consulate. One thing to keep in mind is that this has nothing to do with change of status cases. So imagine you come in on a tourist visa and then you change your status from visitor to, let's say, an E2 visa. That would be a change of status case. That's not an adjustment of status. And there's nothing in here that suggests that those cases would be affected. So I think that some of those tourist visas to employment-based non-immigrant status categories, I don't think those will be affected by this. So that's another thing to keep in mind. I imagine there will be litigation around this. I think that it will probably be filed relatively soon because this is such a massive departure from the prior norms. Now, another question that I can see coming up is, okay, so I filed my I-485 application for adjustment of status several months ago, and what if I get denied? Okay, what is that going to look like? Well, if you get denied, most likely they will put you into removal proceedings in front of an immigration judge. At that time, you can pursue your adjustment of status in immigration court. So you would have a second bite at the apple and try to show the immigration judge that this case is worthy of being adjudicated here and you shouldn't be forced to return home to process at the consulate. Depends on what judge you get, but I think that I'm hoping that some judges will take a stand and find extraordinary circumstances, where USCIS maybe didn't. So that's probably the process that you're going to go through in those circumstances. Like I said, this just came out. We don't know how this is going to be implemented, but this is something we're going to be keeping an eye on. It's going to affect a lot of our clients, present clients and future clients. We're going to have a lot of RFEs that we have to respond to in the coming months, is my prediction. So we will be posting more on this as this new policy kind of gets illuminated and we understand, better the effect and how it's going to play out. So stay tuned and we'll try and provide as much information as we can. Thanks.